Hello, I am Attorney Tammy Saltzman, and you are watching Divorce Connection Network. And today I'm so pleased to have back one of my co-counsels in the world, Charles Jamieson. How are you?
Tammy, it's always great to be here.
Always good to have you too. Charles is board certified family law attorney, someone that I respect and admire in our community, and he and I are going to talk to you about relocation.
And that's a very difficult issue that our clients often come across. We live in a very mobile society, Tammy, as you know, particularly here in South Florida. So we're always seeing the question about one spouse after they've been divorced. One wants to relocate with the children to another state, even sometimes to another country.
That's correct. And it could be brought upon by a job offer. It could be brought up upon a educational opportunity. It could come up when you meet a new significant other and they live in a different state. So we hear it all, don't we?
Right. And we could even have a situation where you get involved with another person and you remarry, and all at once your spouse has to relocate to another state. So we have all these different factors coming around.
And you don't want, you have problems when that happens. So let's talk about it. What are the rules here in the state of Florida when it comes to relocation?
Relocation, particularly after a divorce or other family law matter has been filed, is one that you have to follow very specific rules. You have to file a petition for relocation. It has to be under oath, and it has to have particular information contained in it. Where are you going? What's the address? If there's a job offer, you have to attach the job offer. And you have to have a general game plan as to what kind of contact you're going to provide the parent that's being left behind.
That's right. And quite often I see the parents do a lot of research on the school systems and the communities. And, it's important that you get a full understanding of the new place and how it's going to affect the children, right? Because we know in our courts, the standard is what's in the best interest of the children, right?
Absolutely, and these petitions are no different. The standard by which the judge must establish a relocation can or cannot occur is by best interest of the children. But you're very right. Any attorney who's worth their salt is going to tell their client, you cannot go to court on relocation unless you have your full game plan absolutely mapped out beforehand. You can't just be going on a whim because there might be a job offer or because you think Montana is great to raise children in the country. You have to have a specific game plan that shows how this is better for the children, how this economically advantages you and your child, and most importantly, what kind of relationship does the child have with the community, with the parent that's been left behind, half siblings, if any, and then any other family members. Let's say you have lots of family members here in South Florida, and then you want to relocate your child into a place where there are no family members. So this is a very fact-intensive issue, and it's not one for the weak of heart, the weak of knees to go forward with, or poor planning. This is not something that's spur of the moment. It must be carefully planned.
Now, the state of Florida does have what is considered an out-of-state parenting plan, and it's a general outline of some options that can be offered to the parent that is staying behind.
That is correct. There's what we call, at least in our circuit, the 15th Circuit in Palm Beach County, a proposed standard visitation plan if you're going to be moving outside the state of Florida. But that does not govern our judges. The statute says we must look and see if the quality of the relationship in nurturing a continuing, meaningful relationship is going to occur.
That's the standard, okay?
That's correct. But that doesn't mean, however, that you have the same type of visitation every other weekend or 3 days a week or 4 days a week. It means, can you provide a meaningful relationship? And this is where it really gets tricky, because even if you say, for instance, we have a case out there that says they were going to Texas, and they planned 11 trips back to Florida during the course of the year. And even then the court said that's not quite enough. But again, there were other fact patterns. They didn't see, in that case, the economic reasons being significantly strong enough to go.
They're going to weigh all the facts. If a child is living with mom and mom wants to relocate, but the son has a very close relationship with the dad. The dad's coaching his softball games. He's taking him in the winter to hockey games. They're really intermingled. It's going to be very hard to sever that relationship, and the court would not think relocating that child would be in the best interest.
Right, there's a lot of factors in the play.
There's a lot of factors.
So just to go to the opposite of what you
Let's.
just said, there was a recent case that came out a year or so ago from the Keys where the mother was able to get a successful relocation from the Keys to Atlanta. But in that case, she was going to make 2.5 times more money. The company was going to pay for the transportation for the child back and forth.
Wow.
And even more importantly, and this is how all these factors play together, the father really had 2 jobs, really wasn't exercising visitation or time sharing, and when he did have time sharing, his mother was actually taking care of the child. So the court really looks at all these factors in sync with each other. But that's very important. It's also very dangerous, however, for someone to relocate before getting permission to do so. And one of the reasons is the court can immediately order or have a hearing to see if the child can be brought back. Clearly, our Constitution says you have the freedom to relocate as an adult. Courts can't keep you from going anywhere that you want to. But the courts here in Florida, once they have jurisdiction of the child, may in fact enter an order that says the child remains behind, which is why it's ever so important to file that petition appropriately.
Right, and that is what starts and gives the court the jurisdiction. So if you're a married couple and you do not have a petition pending in the court, or there is no divorce in the court, or there's nothing in the court doesn't have jurisdiction over a spouse to relocate with the children, whether or not the other spouse agrees or not. You might have a kidnapping, a federal offense, there could be a lot of other things, but it's not going to be the court bringing that child back.
Under the statute, absolutely right. The statute says there must be a family law action of some type pending, but here's the rub. There are still civil actions you can institute to bring the child back. Not nearly as clear-cut as the statute, but clearly a parent who has a child removed may still go to court. Then it depends upon what the judge's personalities is, and as you know, what their issues are concerning relocation under those circumstances. I
was recently in a relocation case where the father wanted to relocate, and he was 50-50 time sharing with mom, and mom didn't want the relocation. She was situated here, and it turned out that mom was able to find that where dad was going to move, right next door was a sex offender. And the judge said, absolutely not. Now, that was quickly remedied by dad canceling his lease, moving to a safer part of town, doing his own research on who would be available. Now, there's lots of ways to make up visitation, even when you have a 50-50 timeshare. A lot of times we see all the holidays going to one parent, the entire summer going to one parent. There are ways to have quality time and a relationship with the children even after a relocation if you have the right parenting plan.
And you make a very good point, because again, the statute makes it clear we're not going to recreate what you had here in Florida hour for hour, overnight by overnight. What they're going to be looking for is what your proposed schedule is in terms of creating a meaningful continuing relationship with the parent left behind.
And that can happen. It can happen in a lot of different ways. Most recent case of mine was a mom who relocated and the son stayed here to continue in high school with dad. And mom moved up to Indiana for a job opportunity. The son flew up the first weekend of every month. A lot of times that's a holiday weekend like Labor Day, Memorial Day, so it got extended. They were able to go to the correct airport so that they timed it properly. Like they would fly into one airport and fly out of another, and they cooperated, the parents, to make the experience work for the kid.
And that only goes to show you, there's about 11 or 12 factors the court looks at, and one of them is the preference of the child if the child is of old enough age. A later teenager obviously is going to have a different opinion than a younger child. But they also look at the community record. What is the child doing in terms of high school, extracurricular activities, church events, that type of thing. And again, When you're dealing with older children, what they're going to say or their preference, particularly in terms of their peer development, is going to have a big sway with the judge.
That's right. And sometimes in these cases, guardian ad litems are appointed to really talk with the kids and learn more about the kids and provide a report to the court about what's in the kid's best interest.
The judges are always interested. They don't want to see kids coming to court because it makes them feel,
Right.
it makes children have to pick sides one way or the other. That's a lose-lose situation for the children and for the parents. So the courts are always going to be looking for that way to make it easier for the kids.
And so remember that if you feel that the kids' voices aren't being heard and they're not teenagers and they can't go before the judge, you might want to ask the court to appoint a guardian ad litem, or you might even want to hire a private guardian ad litem to hear the kids' point of view and see what exactly it is that they want.
So again, it all goes down to make your plans ahead of time. And when you think you have your plans in place, go see an experienced attorney and then run them through them and see what else you can do to help maximize your opportunities to relocate.
As I mentioned, Charles Jamieson is a board-certified family law attorney. His office is up in West Palm Beach. You'll be able to find his information on my website at divorceconnectionnetwork.com. Thanks for watching, and we'll see you next time.
As always, thank you, Tammy.
Thank you for coming.